morning or good afternoon or good evening, depending on where you're joining us from today. And thank you for choosing to spend some time with us today. My name is Brenda McPhail. I direct the Privacy, Technology and Surveillance Program at the Canadian Civil Liberties Association. And I'm here today moderating a panel on surveillance technologies in these COVID times that brings together 5 civil society members of INCLO, the International Civil Liberties Organization. And INCLO is a network of 15 different independent national human rights organizations from the global north and south who work together on interests that are both national, but also have international importance, leveraging the work that we do at home to share and to help one another, as well as we all grapple with the ever-emerging challenges to rights and freedoms that are generated globally, and in particular in this context, with the evolution of new kinds of technologies. Joining me today in alphabetical order, we have Gilgan Moore, who's an attorney and director of the Civil and Social Rights Unit as the Association for Civil Rights in Israel. Hey, Gil. Daniel Kahn Gilmore, who's a senior staff technologist for the Speech, Privacy and Technology Project at the American Civil Liberties Union. We have, Martin Mavanjina, the Program Advisor on Transitional Justice at the Kenya Human Rights Network. And last but absolutely not least, we have Siddharth Singh, who's a law officer in the Human Rights Law Network of India. They're all ridiculously accomplished people with impressive CVs, but rather than spend time here describing their many accomplishments that you can look up online, I'm going to let them demonstrate their skills instead, as they are going to succinctly, in 5 minutes or less, describe some of the technologies that were implemented in the context of the COVID-19 pandemic in their countries, and the work that they and their organizations have been doing to ensure that rights remain protected during these times when public health is too often being used as a motivation for creating and implementing tools that are capable of intruding ever more deeply in people's daily lives. So with that, Gil, if you'd like to lead off, please.
Yes, okay, thank you very much. I'm just gonna start a little presentation here. Okay, so we are talking about contact tracing, and we are trying here to come for some conclusions a year later than our previous meeting in the previous ConRights session last year. So when we are talking about contact tracing, there are several models. Of course, the basic one is just human epidemiological investigation. The second one is that many countries used is a voluntary contact tracing app. The third one is a mandatory contact tracing app that was used in some countries like India. And the fourth is what I'm going to talk about is using surveillance tools, a cellular tracking like we had in Israel. And the unique model of Israel that we, as I will later tell you about, fought in the court in Israel, is the decision of the Israeli government to use the Secret Security Agency, the GSS, in Israel to use its surveillance capabilities for contact tracing. Why the government did it? Because the GSS already has a database with communication data of all Israelis. The GSS can process the data into information, including locations and contacts, very rapidly and easily. So it was for the government eye, in the government eye, it was a fast solution, a compelling one, enforceable and immediate. So when the first wave of Corona started in Israel, the government decided on March 16 to issue an emergency regulations to allow the GSS to use its tools, its surveillance tools for contact tracing. We kind of immediately appealed or petitioned this decision to the High Court of Justice in Israel, claiming that this is an unconstitutional move by the government. So the first success of this petition was the court forced the government to bring this for a parliamentary oversight. But the government controlling the parliament, the Israeli Knesset, very quickly authorized the GSS to continue with its contact tracing with the approval of the subcommittee for intelligence in the parliament. So we continue our fight in the court, and on April 28th, we had the very big success in the court. The first decision that the court ruled that if should the government decide to continue using the GSS, it must go for a full primary legislation in the Knesset. It cannot do it based on an administrative decision. And then for a while, they stopped using this tool for contact tracing, but then we had the second wave of Corona started in Israel. So the Knesset quickly passed a law allowing the GSS to continue contact tracing. So we filed another petition, and finally, after a few months, on March 1st, the court accepted our petition and limited the use of GSS surveillance only to those who refuse to cooperate with epidemiological investigation, which basically narrowed it to a very minimum scope. And a few weeks later, the Knesset committee ended the GSS tracking completely. So this was a very big success of the Association for Civil Rights in Israel. But let's talk a little bit about whether or not this tool was even effective in stopping the corona. So I'll give you some numbers. As you can see in the blue, this is the total number of people with COVID during the third wave, which was the worst wave of corona in Israel. So only 58% of all the people that were having COVID found to be in close contact by any mean, human questioning or GSS before that. The rest just found out that they are sick without any notification from anybody before. And the GSS exclusive contribution for this was only 16%. So the government might say that this is a lot, but it's only 16% of all the people that were having COVID in this third wave. Okay, so another interesting number, how many of those who were isolated eventually got sick? So if we're talking about the GSS tracking, so you see that for any person that was found to be sick after was found to be in close contact with someone else, about 19 people were not. So only 5% of those who were found to be in close contact were eventually sick. And to compare with human investigation, for anyone that was found to be sick, 9 people, less than 9 people were forced to be isolated, and they did not eventually got sick. So it showed that the tool is not accurate. It's not good enough for contact tracing. And last data is about appeals. If you got anyone that was found to be in close contact by the GSS got an SMS from the Ministry of Health. So people could appeal this decision for self-isolation for 14 days. The total number of people that got an SMS from the GSS tracking was more than 1,600,000. As you can see, a lot of people appealed this decision, and about half or a little bit more than half of the appeals were accepted. It means that this tool was so inaccurate. It was a huge amount of cases of unjustified isolation orders. So the grave violation of privacy in this case was added to a grave violation of freedom of people. And obviously, as we can see, a technological tool like phone tracking was not a very big success in the mission of contact tracing. Thank you.
Thank you. It's actually fascinating to see those statistics. Those are the kind of numbers that here in Canada, we wish that we had. So it's really interesting to see the actual data that you have about the effectiveness of your tool. Our next speaker is Daniel Kahn-Gilmore.
Hello. I echo Brenda's sentiments. Having the hard figures is really interesting, and I think the stories that I'm going to tell you about what's been going on in the US have a lot to do with failure to coordinate and failure to capture data in an effective way. So we don't actually have the same kind of figures available to us. Here in the US, we had a wave of different proposals early on. I don't know if you were on the call on this particular COVID panel at the last RightsCon. We talked some about the different types of exposure notification or contact tracking contact tracing that had been proposed. None of those were widely distributed within the US, with the exception of the Google Apple exposure notification systems. And those were done in piecemeal fashion. We have 50 states and several territories, and it was basically done state by state, and different states progressed at different times, and they had slightly different apps. Some of the apps were just Google Apple exposure notification systems, the sort of wrapper around the APIs exposed by the underlying tools. And some of the apps were those plus additional things like symptom trackers. We did not end up with nationwide. There was one nationwide part, which was the laboratory that collected and redistributed the signals from the Google Apple exposure notification. But we didn't have a clear reporting mechanism to be able to tell the sorts of figures that Gil just presented. We also didn't have a significant uptake. It wasn't like we had anything approaching 100% uptake, in part because not everybody has devices that are capable of running those tools, but also in part because of significant distrust, even despite the fact that the exposure notification mechanisms had more privacy protections than some of the worst ones that might have been on offer. One of the main problems that we had with these toolings is that while the exposure notification systems were capable of producing results similar to what Gil described, every notification doesn't mean someone was actually sick. It just means that they got a notification, and we lack significant social supports for people who are needing to isolate, which means that a notification for someone who is otherwise not going to be able to get food on the table for their family isn't actually particularly useful for them. So in terms of effectiveness, even the folks who do use these systems didn't have as much of an opportunity to actually respond to them. And I think we need to be measuring public health effectiveness based on the entire scope of like, how does this actually affect people's lives? How does it help them to defend themselves against the virus? And if the answer is, well, I got a notification, but I got to go out and go to work anyway, I might be getting other people sick, and I'm just going to cross my fingers that I don't get ill, the notifications aren't particularly helpful for them. And so I think that was an additional factor in depressing participation, because if people felt that a notification wouldn't help them, they wouldn't participate. We are also now in the phase of grappling. We have widespread vaccines. We also have widespread vaccine resistance in the US, people who are uninterested or actively refusing to get the vaccine. And we have decided that there will be, there's no nationwide mandate for a vaccine passport. Here at the ACLU, we actually don't think that digital passport is a good idea. There are issues of equity and distribution again for that. Like I said, not everybody actually has a device capable of offering a digital passport. And in practice, even the people who have them may have as simple a failure as low battery, which shouldn't prevent you from participating in society. We have two sort of contenders publicly for this. There's a Common Pass application, and in New York State, we have Excelsior Pass. These are digital apps, but they do have a paper fallback. They're offered as digital apps, typically with the suggestion that they would be useful to hide, to be more privacy preserving as a digital app, and to prevent fraud. But because there's a paper fallback, the fraud risk just sort of falls back to whatever the paper fallback is. And so it doesn't actually prevent the fraud that much. And again, we can't rely on fully digital. At the ACLU, we're pretty clear that we want there to be a sort of right to paper, and we've been pushing on that. So it remains to be seen what we're going to end up settling on. It will, again, probably be a piecemeal situation here for the credentials apps. But yeah, I think the story from the US really is one of sort of failure to coordinate and at the same time, problematic tracking mechanisms going forward. I hope the next person goes on.
Thank you. And thank you for bringing up the issue of, the necessity and the problems created by a lack of social supports that wrap around the technologies. Too often, at least in my context in Canada, the technology was talked about as a kind of silver bullet that was going to help fix things. And the things that needed to be fixed were much more fundamental, like, does everyone have access to an affordable device in the first place? Does everyone have access to healthcare that they can reach by public transit? Does everyone have access to a paid day off if their app tells them that they're maybe at risk, that they're exposed, or they need to go to a test? And are we forcing people to make choices between paying rent and putting food on the table and taking care of their health, and by doing so, taking care of everyone else around them? So really important context to bring in, even in this context that's that's focused on technological interventions. Our next panelist who's going to talk about his jurisdictional context is Martin. Go ahead, Martin.
Thanks, Brenda. Good morning, good afternoon, good evening, colleagues. I'm Martin Mabenjina, and I want to share the context in Kenya on surveillance tech and COVID-19. So I must point out that the first case of COVID-19 in Kenya was reported on the 13th of March 2020. And with that came a raft of measures by the Kenyan government. Now, some of these measures were strategic, policy, regulatory, and legislative levels, including the use of surveillance technology to contain the spread of the pandemic. These measures limited, I must point out also that in as much as the government embraced these measures with good intention, these measures limited the exercise of people's rights and liberties, such as the right to privacy and freedom of assembly and movement, amongst others. Kenya employed the use of technology to contain the spread of the pandemic, and this was manifested specifically around contact tracing. There was also use of geolocation of smartphone data, cyber surveillance, and facial recognition, with the aim of detecting movements of potentially infected persons and to warn populations of people who have likely been exposed to the virus, and also to control quarantines and track and locate infected individuals, as well as limit travel. However, in as much as the state employed the use of technology in containing the pandemic, it created a scenario whereby the Kenyan government had unfettered discretion to actually conduct mass surveillance, even beyond the essence of the very purpose of actually containing the virus. And what we did is, what the Kenya Human Rights Commission and other civil society organizations did was that we engaged human rights networks, and we monitored most of the government's deployment of technology and what kind of technology they used. And we were able to come up with key reports that raised key fundamental concerns, specifically around privacy rights of individuals and also around data protection. The first key concern that I can point out is that the surveillance measures and practices adopted to contain COVID-19 or the COVID-19 pandemic, including the coronavirus apps, did not comply with the three-part test under international law and national laws guaranteeing the right to privacy, data protection, freedom of expression, and access to information. The other key concern I can point out is Kenya's Data Protection Authority was not independent and as such lacked the function and operational capacity to oversee surveillance measures and practices deployed by the government. So in other words, the government of Kenya was having a field day without any form of oversight, and if you don't have any form of oversight, your guess is as good as mine. Third one was that the third thing I could point out was that state actors, that is the relevant state agencies, also private actors, that is our mobile service providers here, were used to collect data, data, process, and share that data with the relevant state agencies, specifically around sensitive health data. But in doing this, they breached many citizens. They breached the privacy rights of many citizens, and there were no mechanisms put in place to actually guarantee first and foremost, how long this data can be held by the state, and secondly, that is more critical is when the state can actually deem that they no longer need to use this data. So in absence of oversight, in absence of any oversight mechanisms that were put in place, then this gave the Kenyan government unfettered discretion to conduct mass surveillance. In terms of, so in Kenya, we've not yet explored a broad discussion around having the digital passport. And that is primarily because the country is still grappling with the pandemic. As you may all be aware, we don't have, we've actually technically run out of vaccines. So that could, but in the event that that discussion was actualized by the Kenyan authorities here, then the thing, then the key concern that would arise would be around the privacy and data protection. In as much as we have pieces of legislation that provide for data protection and privacy, there's been a weakness by the state for a very long time in implementing some of these legislative provisions. So I'll stop at that. Brenda, over to you.
That was brilliantly within about 3 seconds of 5 minutes. Thank you. You win the timekeeping award so far for the day. And thank you also for raising the crucial issues around oversight and state accountability for the way these technologies have been developed and are rolling out. Because I think that's another important piece of this COVID tech puzzle. Not just what are the technologies that are rolling out, but what are the legal authority for the use of those technologies, and then who is watching the watchers who are then watching the ill. So bringing in some more really important themes. For the audience, I'm just going to note we are starting to see questions coming in. Thank you for that. We will get to those at the end. I want to make sure all our speakers have a chance to get their initial comments in first. And with that, we'll turn to our final panelist, Siddharth, please.
Thank you, Brenda. Hello, everybody. I'm Siddharth from the Human Rights Law Network in India. India is, I think, a country where there is generally there's an inclination to accept new and upcoming technology rather readily, with not as much of a concern for privacy. I think traditionally privacy has not been a household word in the families or in society or with the state. Of course, there's now an increasing consciousness and awareness about privacy concerns. But overall, an average Indian, if there's any introduction of a new technology by corporates or by the government, I think an average person in the country will either very enthusiastically jump onto that technology or accept it without raising too many questions. And this has allowed, I think, the government to introduce certain measures which more than push the boundaries and has allowed the government to introduce some technologies and some principles, maybe not the whole technology yet, but at least some principles which the government would not have maybe thought of introducing had there not been a pandemic to provide the cover for it. And this project started with the first contract tracing app, which was Arogya Setu. There's a lot to be said about it, but it was different from a lot of other contract tracing apps around the world in that it took all your information. It took your name, your age, gender, profession, and of course, it was constantly tracking your data. One of the major concerns with the app was that the terms and conditions of the app itself said that the government of India will not be liable if there is a breach of personal data which has been entered into the app by a user. And this was one of the major reasons why our organization then challenged the app in one of the high courts, in the Karnataka High Court, also on the ground that the government had made the app mandatory, as was mentioned earlier in this talk, that Arogya Setu was initially actually made mandatory for all employees of government as well as private companies. And it was subsequently then made mandatory for rail travel and for air travel as well. And then, after that, shopping malls and market areas also took it up and said that if you have to enter the area, you have to have the app on your phone. Several problems with the app. First of all, most Indians do not have a smartphone. The total penetration of smartphones is about 40%, and that includes the urban areas where there would be a much higher ratio of people who have the app. That was one of the obvious problems. But another problem was that it didn't really give you accurate data. You could be passing somebody in a car, or your neighbor could be having it, and it will show you that you have come in contact with a COVID patient. And increasingly, people stopped really having any trust in it because they were used to the app showing all these false positives. And so over that time, it really became pointless very quickly. Despite that, the government for many months insisted that it will be mandatory for different things. In the High Court, when this was challenged, the government changed its stand a little. It made certain concessions, said that it will not be required for air travel or rail travel. It then said that it will not be mandatory for any government benefits. But the major intervention by the High Court happened in the fact that the app was sharing data which was entered into the app for contact tracing with third parties as per it was the protocol, it was the Arogya Setu Access and Knowledge Sharing Portal 2020. They made the structure to share the information with third parties. This, the High Court restrained the government from doing and said that unless you have informed consent from the users about sharing data, you can't be doing that. So that was one of the successes we were able to obtain with regard to this app. But there was some more almost explosive technologies which the government was already thinking. One of them was announced by a government company called Basil, which works in the Ministry of Information and Broadcasting. It has nothing to do, the company and the Ministry of Information and Broadcasting has nothing really to do with healthcare. Yet it releases a tender, which is a bid, for certain COVID-related equipment. It's including PPE kits, gloves, and so on, and also an overarching patient tracking tool, which is different from a contact tracing tool. This was now a patient tracking tool and a tracking tool for health workers. So it suggested, it actually called for tender for a wristwatch or an ID card or a phone app, which will track the movement of the health workers. And if the health worker steps outside that geo-fence zone, then there will be an automatic fine which will be imposed to them. Or correspondingly, if it's a patient, then the language use is actually very interesting. If the language use is very interesting in that they have used the word suspect rather than a COVID patient. The heading is COVID patient, but the language is actually suspect. And I'll just take a minute on this. I know I'm over the 5-minute mark, but I'll just take a minute and share some of the requirements that were part of that bid. So this is the requirement of Basil. It starts with sanitation, chamber, COVID test, and so on. This is not really for us. Then it goes to a personnel tracking solution, which will have geofencing of zones and providing the wristwatch and all that I just told you about. And then there was also a bid for an online thermal fever sensing system. So this is where they introduce FRT very, very smoothly. And they said that the application shall have face detection feature for both thermal and visual stream, and that the software shall record both video and image. I'm moving a little fast, but I just want to come to the patient tracking tool. If you look at the first point, it suddenly changes its language and becomes about intelligence investigation platform and tactical tool to detect, prevent, and investigate threats to national security using CDR, IPDR, etc. So it suddenly moved from COVID-19 patient tracking tool in the heading to national security in the next line. And the next point number 2, software that uses telecom and internet data to identify suspect locations, associations, and behavior, far going beyond any legitimate demand that the government might have with regard to COVID patients. Look at the 6th point, location-based analysis, easily geofence an area of interest, for example, meeting place, airport, mosque, railway station, bus stand, etc. And I stress on the word mosque because it doesn't say place of worship. Unfortunately, one of the initial things that happened with COVID pandemic in India was a rush to blame minorities in the country for the spread of the virus. So therefore, the mention of mosque in this government document is so interesting. I'll now go to the last point, which is point number 12. This software should be able to identify a suspect's behavior, see what he or she does on specific days of the week. Where does he or she order food from? Where does the suspect go for regular walks? Where does he or she work during the day? Where does he or she sleep at night, etc. So in the guise of patient tracking, first of all, should not be a legitimate purpose at all. But in the guise of containing the pandemic, the government is trying to introduce concepts that we want to have the technology to do this. We want to have the technology which tracks every citizen's behavior and associations. This fortunately has not really been introduced in effect yet, but the idea is still out there in the government's mind, and there's a lot of advocacy going on with the government. I'll end with the third and the last thing, which is another example of facial recognition technology. The NCRB, which is the National Crime Record Bureau, has also issued a similar tender for a facial recognition technology which can see through masks. It can obviously not see through masks. It's going to the technology that we have already has some 99% inaccuracy rate, and to see through masks is going to increase that inaccuracy rate. But the government is pushing for all of this in the absence of any legislation protecting data or allowing the government to do any of this. Thank you. And sorry to going much over the 5 minutes.
You had such amazing content that we're all going to forgive you. What a perfect example of the concerns that civil society has been expressing around function creep for these technologies. The example that you provided of the suspect/patient tracking, is sort of the epitome of those concerns. In Canada, I think that our concerns have been less dramatic, partially in part because from the beginning, when contact tracing apps were identified as a thing, that magic bullet that was going to save us all, there was a very strong focus on privacy. Over the last few years, after a series of largely North American scandals, Canadians have become sensitized to the concept of privacy and data collection. So it was reasonably clear relatively early on that if Canadians were going to be offered a contact tracing or exposure notification app, that privacy was going to have to be a consideration. The question was always whether it was going to be a talking point or a reality in relation to whatever kind of dazzling app was created. But in the end, our federal government did choose from a very varied group of apps that with greater or lesser capacity for intrusion, greater or lesser reliance on AI and geolocation and other bells and whistles. They did in the end go with a very simple exposure notification app based on the Google Apple API, explicitly because it was designed to be privacy protective. With the proviso, of course, that while technical privacy protection is important, even that carefully kind of crafted app raised issues for the Canadian Civil Liberties Association in relation to function creep, in relation to lack of wraparound social care, and in relation to discriminatory impacts given that in Canada, at least, we all didn't experience the pandemic equally. People who were hardest hit were those who were frontline workers, who in our country tend to be young or newcomers, tend to be racialized, and because they're working in poorly paid frontline jobs, tend to be in lower socioeconomic income brackets, meaning they might not have the fancy phone, or the family might only have one that they share. So there were also, of course, very serious issues around social exclusion from this tool that was being pitched as, you know, the great benefit to people across Canada. In the end, although they tried hard to make the app privacy protective, partially for privacy reasons, partly for technical reasons, in our federal system, where provinces have primary responsibility for health and the federal government does not, but was sponsoring the app, we ended up with 9 of our provinces and territories out of 13 agreeing to use the application. And in our country of just shy of 38 million people, only 6.6 million actually downloaded the app. Out of 1.4 million infections in Canada, 33,690 notification keys were sent out. So that's a very small percentage of actual infections that were picked up by the application, and then an even smaller percentage of that generated notifications that actually served some kind of warning function. And we don't have the data about what people did once they got those warnings. We are in the middle in Canada of an efficacy audit being conducted by Health Canada in conjunction with other ministries and the Office of our Privacy Commissioner. That audit was promised to be done last winter. It'll probably be done for next winter. So by the time we're moving out of the pandemic, we may actually get some data about how effective our app was, but it's not looking good at this time. The other hot topic in Canada is around vaccine passports. We actually have 2 provinces who just over the last 2 weeks have announced a version of that. And one of them, particularly problematically, is explicitly saying it will be used to confer benefits, such as not having to quarantine for 2 weeks after traveling outside the province, on those who have 2 doses of vaccination. So in Canada, we've never had mobility restrictions between our provinces in the past. It's not clear who or how it would do the monitoring in relation to cross-border travel in that context. And obviously we've got significant concerns about creating a 2-tier society, about conferring benefits that form a de facto form of coercion in our legal context where vaccination is not mandatory, and where our Constitution would very likely, if not prohibit mandatory vaccination, at least cause a long series of legal challenges that would have to be decided before that was determined. We have limited jurisprudence where vaccines are mandatory in particular work contexts with vulnerable populations, but beyond that, the conversations around mandatory vaccination in Canada are both lacking and likely would end up being unconstitutional. So creating a passport, a vaccine passport that confers social benefits or even opens up the ability to participate in public life raises very significant issues of coercion, in addition to all of the potential discriminatory impacts that could be caused when you allow a diverse group of gatekeepers, people in retail who are hosting concerts, who are driving a bus, to be allowed the power to view the passports and to make decisions on their authenticity. So you've got, that's problematic. Added to that, of course, you have the issues of the reality that there are people who medically are unable to be vaccinated because of pre-existing conditions. There are people who are unwilling to be vaccinated based on either sincerely held religious belief or other protected grounds under Canada's human rights codes. and accommodations would need to be devised for those people. It's unclear how that would happen. So there's a very complex legal as well as social ecosystem around vaccine passports that we are just beginning to grapple with here in Canada. At this point, we have one sort of very targeted question from the audience that I want to toss out before we move to a few questions to the panelists. And the question, which I suspect was directed at Gil, is where is your data coming from, and are there any plans to publish it?
Okay, once the authorization of the GSS to use its tools for contact tracing was enacted in law, the members of the parliament decided that the Ministry of Health will have to report once in a few weeks to the committee in the Knesset with the numbers of all the numbers that I use for presenting the numbers. I don't have any summary in English that I can share, but this was just a summary of a weekly reports that were given to the committee in the parliament.
Thank you. And for the audience, please feel free to ask any further questions, and we will absolutely get to them in the conversation. At this point, we were going to turn to a question about contact tracing and whether or not in your countries there's been any data on the efficacy of this. Gil has already preempted that question. I've spoken to it a little bit, but I'm just wondering for the other panelists if you have any comments on any evaluations that have happened or are planned in relation to contact tracing in your countries.
Thanks, Brenda. Unfortunately, in Kenya, there've been no positive reports on the impact of contact tracing, the use of technology 1 year on since the COVID-19 pandemic was reported. In fact, state actors and private entities have collected, processed, and shared personal data, including sensitive health data, in breach of data protection principles and safeguards in national data protection laws. In particular, they've failed to integrate data protection principles, including purpose limitation, data minimization, data retention, and prior and informed consent into the design, development, and deployment of technologies, products, and services to tackle the COVID-19 pandemic. So it's more or less a bleak situation here in Kenya.
We've also failed in the United States to gather any sort of robust, meaningful metrics across the different states. One of the big problems with the U.S. is we have, similar to Brenda, your description of the Canadian provinces having sort of sovereignty over that. The decisions are made statewide, and we have not had. We've actually even had difficulties within the United States of gathering reliable data from all states about just how many COVID cases there are. And the data to determine efficacy would require us to actually have a standard way of gathering whether or not the cases had the kind of alerts from the exposure notification systems. And we just don't see that coming in across the country. Gil, I admit I'm a little bit envious of the fact that for all the problems that the GSS proposal introduces, they actually had figures they could report. It's good to be able to see that and say, look, the system didn't even really do as much as we thought it would do. And it has the downsides.
To the best of my knowledge, I don't think the government of India has shown any interest in gathering any such data compared to the kind of enthusiasm that the government had initially, to the extent that people were getting bail orders with the condition that they had to download the app. But really after that, after a few months, I don't think there's any push on that. And there's no data available.
I think it's really interesting to note that for most governments who seem eager to find new ways to add surveillance to individuals, the willingness to be surveilled themselves and measured at the efficacy of their work is much, much lower. And I think that's a telling observation about the way that surveillance ended up reflecting actual power dynamics in our societies.
As it seems to always do, despite whatever kind of socially beneficial framing may be put around it. I'd like to take a few minutes to go back to vaccine passports, partially because it's a current obsession of mine with the way that it's moving forward in Canada. I think everyone has spoken, or almost everyone has spoken briefly to the plans in their country around such passports. But I wanted to give you an opportunity to speak more directly about the position of your organization in relation to vaccine passports and the kinds of concerns you have about rights that are linked to them. Here in Canada, I mean, the CCLA's position is basically that at this point in the pandemic, it's very hard to see that they're either necessary or proportionate to the kind of invasion they might create, because we don't have a tradition in our country of having to show our papers in order to access private life. And the choice to be vaccinated is a legally valid one that each individual holds. So requiring them to show proof of that legally valid choice in order to participate freely in our democracy seems to be an overstep at this time, particularly given the stage of vaccination we're at, which is a very less than 10% of the Canadian population has been doubly vaccinated. We're in a position where we've got about 70% of people with a single vaccination shot. So turning it to you, is there anyone who is able to speak about these issues in your country?
Yes. Well, in Israel, actually, the issue of green certificates or passport was eventually not a very big deal because we had such a very quick and effective vaccination rollout. And actually, when the numbers here dropped because of the vaccines, about 2 weeks ago, we even stopped using them for any place in Israel. They are only now relevant for if you want to go abroad or something, but you can enter everywhere without the certificate because the numbers of people with COVID is so low. But as I told you before, we saw that the problem that we had with the GSS tracking was the only problem, and when the vaccination rollout started, we thought that now we can rest a little bit, but we were wrong because once they started vaccinate people, the government was very eager to make it as efficient as possible, and the Prime Minister himself, Netanyahu, saw it as a personal like a success story of making, the Israel the first vaccinated country in the world. So this eagerness was translated into a very horrific law that was passed in a very quick way in 3 days, I think, that allowed the Ministry of Health to receive all the lists of people who did not get the vaccine from their health suppliers, HMOs in Israel, and to forward all this information to cities across Israel and also the ministries of education and welfare in order to encourage people to get the vaccine. They didn't explain how this encouragement should take place and what is the purpose of all of it. And this is obviously medical information that should not be passed to anyone. So we filed another petition to the court, and this time also the court accepted our petition very quickly and froze the bill and issue an interim order ordering the state to explain the bill. And then I think that the Ministry of Health just understood that this bill is not, they will not be able to defend it in the court. So they just, eventually dropped it altogether. So it was another big victory. And the second point is that we started seeing in places like stadiums and theaters, private companies that were selling facial recognition technology as and they use the fact that those places needed to check or to verify that people had a green certificate that they were vaccinated in order to start using it in those places and sell it this technology to those places. So we saw, for example, in the stadiums in Israel, in Tel Aviv, that everyone that bought ticket had to first, they were asked to first go to this company and do this procedure with this company, and nobody was told that this is a facial recognition technology, that their biometric data is taken. People thought, oh, this is a nice way to just jump the line and not wait too much in line. So we also wrote a letter against this kind of use of facial recognition technologies in this term.
I wanted to highlight a distinction between different types of passports that we've talked about within the US context. In the past, we've had folks within the US talking about immunity passports as distinct from vaccine passports. And I think those can often be conflated, especially in societies where there is widespread access to vaccination. We think of immunity as being vaccination. Another form of immunity, of course, is having been exposed to the virus or having actually gotten sick and recovered is likely to confer some level of immunity. In places where vaccinations are not widely available, I can imagine, I know that we talked about this within the US before we had vaccinations available, and I can imagine this will come up in other contexts. The ACLU is quite strongly opposed to immunity passports in general. They create some perverse incentives that are particularly damaging. If you have an immunity passport and you don't have freely available vaccinations, then you're basically saying, and that passport provides access to parts of public life that are important, like employment or transit, then what you've done is you've actually created an incentive for people to expose themselves to the virus in order to get an immunity passport to be able to carry on with their daily lives. And that's a really insidious form of injustice that lands particularly on the people who already have the least resources, the least options. So we are quite strongly opposed to the idea of an immunity passport. For vaccination, we have a history of requiring vaccination in certain contexts in the US. Brenda, you mentioned vaccination for certain forms of workplaces. Like we would like our healthcare workers to be vaccinated so that they can't spread. We also have a history of requirements of vaccination in situations like public schooling. And it's not clear exactly how that will work out. Again, we don't necessarily need a vaccine passport for that. We just need evidence of vaccination. And so the ACLU is quite strongly opposed to the idea of digital only vaccine passports, since this is a tech session. But we expect there needs to be some sort of, or we've been tentatively calling it a right to paper.
We have one more question from the audience that's relevant here, which one of the significant factors is that these technologies are introduced and not audited. We've touched on that in the contact tracing context. Failures can't be established as a consequence. Given that no one knows how long antibodies will last or how often vaccinations will have to be done, what would vaccine passports even mean? Someone could respond to that very briefly. We've got about 5 minutes left, and I want to give you time for a single sentence closing statement. Do they mean anything given the current state of what we know about vaccination and what we don't know?
So most vaccine credentials that I've seen include timestamps or dates. I agree that the science is unknown. We haven't actually had COVID-19 for too many years to be able to figure out whether the vaccinations will last. So I agree with the questioner that there needs to be scientific and medical consensus around what sorts of immunity these vaccines are intended to confer.
As we're wrapping up, I'd like to give each of the panelists a chance to say in 1 minute because we are down to 4 minutes left in our session and we are going to get turned off at that time. How do you think that that either the COVID tech that's in place or the implications of it and some of the add-ons to it is going to persist in your country moving forward? I'm going to ask Martin to start.
Thanks, Brenda. So I think post-COVID, I don't think this technology is going to be beneficial to Kenyan citizens. However, it will be beneficial to the state as it has given them overarching surveillance capabilities. So there's strong need for us to push for the quest for strengthening the existing oversight mechanisms to ensure that this surveillance is conducted within the confines of the law, and also within it's done in regard to international accepted standards.
Thank you, Martin. Sarah?
Yeah, that's it.
Well, in our case, I think the government has already shown an inclination to use these technologies for purposes other than COVID itself. So I think the pandemic is going to go on for a few more years, maybe. And in India, it's definitely in a bad shape right now. But I see that the technology will be part of non-COVID activities as well.
Gil?
We are very concerned of the implication of everything we saw last year. I think what we all see in Israel is that how it's very easy, it's too easy to get used for mass surveillance tools used by the government. And I mean, in the beginning, it was a big deal in Israel. Everybody talked about the fact that the GSS, the secret agency, is starting to surveil everyone. But then we just moved to other topics, and eventually everybody just got used to it. And so just show how easily the something that's not normal can become the new normal. So I think now we are trying to look for ways to limit the way that the GSS can use its surveillance tools in general.
DKG, you've got 30 seconds.
I just wanted to highlight one concern about the ongoing evolution of technologies that people have on their own personal devices. Just because the app you installed was initially seemed like a good idea, we really need to think about how we roll them back when we discover that they are not functional. And we need to make sure that we avoid scope creep. As the apps evolve, you could install an update and the update could make things much worse. So I just think that's something that people need to keep an eye on for the local technology.
Thank you. And thank you to the audience who joined us this morning, to Access Now and the conference organizers for giving us this opportunity to have this conversation. I always learn so much when I get to connect with my international colleagues. I hope that, like me, you have found their perspectives interesting and that it opens up some ideas for your work. Thank you very much and goodbye.